The next matter to come before the court this morning is State of Ohio ex rel. Monica Lillis versus Summit County et al. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes to rebuttal. If you're the appellant, wish to reserve any time for rebuttal, if you let me know. I'm keeping the clock this morning and keep you apprised of the passage of time. Court's read the briefs. We're ready to proceed when you are.
Thank you, Your Honor. Good morning, and may it please the court. I'm Jacqueline Corrigan. I represent the appellants in this matter, who are the siblings of Monica Lillis and her brothers David and James Horvath. And I would like to reserve 3 minutes of my time for rebuttal this morning. Now, the question in this case is whether these siblings, and that's how we refer to them throughout the brief for ease of identification, whether these siblings have standing to bring an inverse condemnation action against the city of Akron. Now, the siblings' standing hinges upon the type of taking that they allege that has occurred of their property. They alleged that there was a physical taking of their property by flooding. Nevertheless, the trial court, in dismissing their case for a want of standing, did so based upon cases regarding regulatory takings. And thus, the siblings are asserting to this court that the trial court misapplied an incorrect standard to their case and thus committed reversible error. Now, the siblings, as you know from the briefs, are claiming that they do possess standing on basically 3 grounds: because of constitutional provisions, the statutes of the state of Ohio, and also Ohio's common law. The basic rule of standing is that a party is allowed to come in and plead a claim so long as they have a personal stake in the outcome. And the general rules are that you can show that you have a personal stake in the outcome of a case when you show that you have suffered an injury that is fairly traceable to the defendant's conduct, which is called the causation prong, and then also that injury is likely to be redressed by the relief that you're requesting, which is essentially called the redressability prong. And it is on that prong that the trial court decided that our clients, because their property is not located within the boundaries of the city of Akron, don't have standing to bring a takings claim against the city of Akron for the city's conduct. Now, this didn't have anything to do with the merits of the case. We have briefed some of the facts underlying the claim that were in the motions for summary judgment, so the court can understand what the basis of the claim is. But it is a physical taking of property, not a regulatory taking of property. Nevertheless, where we are asserting that the trial court committed reversible error is by relying on 2 cases from the Ohio Supreme Court. One is Moore versus Middletown, and we have the citation in full in the brief, and also a case, Clifton v. Blanchester, also fully cited in the brief. Both cases are from 2012, and in both cases, the plaintiffs in those cases were asserting a takings case against a town, but it was for regulatory taking. They were alleging a regulatory taking. What had happened was that the town had effected a zoning change on land that didn't belong to the plaintiffs. It belonged to people that were neighboring the plaintiffs. It was on neighboring property. And what the plaintiffs in those cases were asserting was that the zoning change, sometimes to industrial land, was negatively affecting their use and enjoyment, well, not their use and enjoyment, but the economic value of their property. And what the Supreme Court had decided was that when you have landowners who are claiming that a zoning regulation being implemented on a neighboring property, then that injury is not redressable, especially when the property in question that's been rezoned is in the boundaries of a city, and the people who are suing have their property outside the boundaries of the municipality. And both of those cases, Moore and Clifton, the Ohio Supreme Court expressly limited both of those decisions to their facts. And those facts were a regulatory taking, not a physical taking. Nevertheless, the trial court in this instance declared that based on those cases which regarded a regulatory taking only, that the trial court was applying the same rule that property owners who have property outside the boundaries of a municipality lack standing to sue a city for a taking. That rule would be applied to physical takings as well, and we submit that that is error. Basically, what the kind of cause of action that we have is an inverse condemnation. The state of Ohio does not have a direct statutory means by which a property owner can try to remedy the situation where they're alleging that their property has been taken from them by a municipality or by government without first being given proper compensation for the value of their property. But there are a couple of different standards that we apply in Ohio to regulatory takings, inverse condemnation, and physical takings. In order to show a physical taking, which was the case that we have here, and in particular a physical taking by flooding, the plaintiff has to show that there was flooding on their property that was either intended by the municipality or the direct, natural, or probable result of government authorized activity, and that the flooding is either permanent or creates a permanent liability because of intermittent but inevitably recurring overflows. On the other hand, a regulatory taking has to deprive the owner of either all economically beneficial use of their property or has to deprive the owner of the most economically beneficial uses, depending on factors, of course, including the regulation's economic effect on the landowner and the degree of the regulation's interference with things like reasonable investment-backed expectations and the character of the government action. So there are two different standards even to show that a taking has occurred with a physical taking by flooding versus a regulatory taking. Again, our clients were alleged and went through trial to show that there was a physical taking by flooding. So that in a nutshell, Your Honors, is the crux of our case.
Wait, you said, I'm sorry, but you said alleged and went through trial. I was a little paused at that. This was dismissed for lack of standing
After
after
trial.
trial, okay.
Yes, in fact, there were post-trial bench briefs submitted by both parties on the same day. The issue was raised by the city within the first, well, actually before we even began the trial proceedings to the bench. So we had gone through discovery, we had gone through summary judgment motions, we had amended the complaint once, we had dismissed other parties, including Summit County, which is why right now the only party that's here with us is the city of Akron. So we had gone through all those proceedings, and then just prior to the actual bench trial beginning, there was an oral motion made by the city's council to dismiss the case based on lack of standing, and the trial court advised us that we were to submit briefs regarding the issue of standing after the case was over, or after the trial was over, excuse me. So this didn't arise at the inception, it arose literally the first day of trial. So that's why I said we alleged, and then we presented facts on, to try to show our taking, but the trial court never reached the merits. So, if there are any other questions about the differences between a physical and a regulatory taking, I mean, that really is the crux of our client's case, is that the Moore case and the Clifton case ought not to have applied to our client's case. I mean, the Supreme Court of Ohio specifically limited both cases' holdings to their facts. Both cases we're specifically addressing a regulatory taking rather than a physical taking. I will say that the language that the trial court cited and quoted in its decision dismissing the case isn't specific in itself in the sentences that were used to a regulatory taking only, but the sum and substance of both cases is that this is how you look at regulatory takings and the redressability of regulatory takings, not physical takings cases. And yet, even with those cases, one of the things that the court had looked at was whether there was any kind of redressability under Ohio statutes. I think the issue with that is, or the argument with that is that the trial court would have to have the power. Now I take that back. The city itself, the argument is that the city would have to have itself the power to take the property outside of its municipal limits. And that's the redressability. It's like, can you actually get a mandamus order to force the city to begin eminent domain proceedings?
And essentially then, the defense would be, you can't come and take my property. Not that it's been flooded already, I was just thinking the same thing. Hypothetically, say the city of Akron decided that they were gonna come and take the property, Bogart's property, because it was adjacent to Rooster Creek and they needed some more property, or they were gonna go take the property. Well, it's outside of the jurisdiction. They'd have to show all this stuff affirmatively, you'd have a defense at that time to say, no, you can't take that property.
Well, the defense would be extremely limited because,
But that case, it's an affirmative, we're gonna go out, we're gonna go eminent domain and take the property. That's how pretty much this case, the decision was written.
well, I think I'd have to explain a little bit about the defenses available in an eminent domain proceeding. They are extremely limited. Basically, because drains, sewers, ditches falls into a provision of Revised Code 71901 that allows a municipality to take for those purposes, and then 71902 allows the city to take outside its limits for those same purposes in 71901. If it had gone the usual way, where the city had decided, we have a need to take the Horvath's property to build a detention basin, and we have a public use for this, and so we're going to try to bring an eminent domain action. That would be we couldn't really have a defense on that basis, because we're arguing it does fall within the statute, because a reasonable reading of those statutes, and under the case law of, I think it's the 8th and 7th districts, yes it is, sewers, drains, and dishes includes detention facilities.
And counsel, you're about a minute into your 3 minutes of rebuttal. I just want to let you know that.
Okay, thank you, then I'll reserve the last 2 that I've got.
Good morning, Your Honors. Brian Burr on behalf of the City of Akron. I think it's important to initially explain exactly where we are procedurally in this case. This was a motion that was made before trial, and then when the court granted the motion, the court looked only at the allegations in the verified complaint. Whatever happened at trial is not before this court on appeal. The transcript's not with us, and the court never considered it. To the extent that they're saying that the court should have considered that, that's a separate assignment of error that they didn't raise, and that's a separate assignment of error they didn't argue, and that this court cannot go outside of what really the court considered below. And even if it were to try, the transcript's not here. So we have to presume regularity in what the court did, given the lack of transcript if we were going to go down that route.
Right, but I mean, if it's a standing argument, we go all the way back to the complaint, and then we stop there.
Right.
So the defense on the city's part about they didn't raise these things, does it matter?
Well, she keeps talking about what happened at trial, and it's irrelevant. That's the only point. As far as this appeal, it's not relevant to this appeal.
But you're still arguing they are raising now state and federal constitutional issues and riparian
those weren't in the complaint. Those were in the complaint, those were not argued before the court below. They are raising those for the first time on appeal, and this court has consistently held that they will not consider things in the first instance. And if you don't raise them below, you forfeit them on appeal. And on top of that, the actual idea of the constitutional rights, the Fifth Amendment right and the Article 1, Section 19 right to compensation for a taking, even assuming a taking occurred in this case, the amendments themselves don't provide the remedy and the redressability for them. They provide the right. The remedy and the redressability come from other avenues, and those are typically in Ohio mandamus. And that is why the mandamus issue here is crucial, because it goes to the redressability. A writ of mandamus can only order a governmental entity to do something that the petitioner has a clear legal right to do, and the governmental authority inherently would have the authority to do. And in this case, the state of Ohio has consistently held that municipalities do not have the power to take property outside of their territorial jurisdiction, except under very limited circumstances. And none of those circumstances were alleged in the complaint here, and therefore there's a lack of redressability, because the city cannot take, there's no authority for the city to take the property that they want us to try to take. And that's really what the standing issue was below, and that's what the standing issue here is on appeal, because we never even got into the injury and the causation below. That issue was not before the trial court on the posture of how the motion was phrased. And the court never reached that issue when it issued its decision. And when we look at the cases that exist, and that court's decision was right, because Moore and Clifton, even though they involve regulatory takings, and even though they say that they need to be understood in the context of their facts, that's all true. Because under the context of their facts, there is no authority to go outside the jurisdiction under those facts. And they especially list 71901 and 71902 as the provisions that let you to go outside of the jurisdiction of the city to appropriate property. And this all makes sense when you think about, would the city of Akron be permitted to just bulldoze someone's home on the border of our city to put a parking lot in? No, but inside the city you can do that. The city has a large grant of authority under the home rule taking authority to do different activities that you do not have the authority to do for citizens that are property owners that are not within your city.
Making it sound pretty easy for the city to do that even inside the city limits.
Well, there's obviously it would not be easy to. I would argue that it would probably not be easy to do. You're right, but at the very least, like within the city, the authority exists. Outside the city, it doesn't, unless it's granted comes from somewhere else.
What if the city just started using the property, the parking lot that was not in the city? What if they started parking all the trucks and cars and everything on this hunk of land next, adjacent to, but not within the city limits?
Well, then the remedy there would probably be an injunction to stop them parking their cars there. I mean, the remedy there would not be that it's a taking, there's an injunction, because the city couldn't appropriate that property ultimately. And that's the issue here again, is only the fact the only remedy they're seeking is for the city to appropriate this property. And that's just not available to them in this case, because of where this property is located. And to the extent they want to make a difference between regulatory taking and physical taking, the cases, when you look at Lujan, which is the United States Supreme Court case that talks about standing within takings claims, it does not stand for the proposition that they try to make it stand for. The idea is not that there's more strict scrutiny for indirect taking versus a direct taking. It's still the same level of scrutiny. It's just that when you have a direct taking, you can point to it and say, that meets the causation, that meets the redressability. We know that already occurred. When it's an indirect taking, you have to go through multiple steps to meet the same level, to meet that level of proof. And it's not because it's more strict scrutiny, it's just that the evidence is not as easy to obtain. And in this case, and in these cases talking about physical takings versus regulatory takings, it's actually more about direct takings versus indirect takings. And if you look at their petition for a writ of mandamus, they're not alleging the city of Akron has a sewer that dumps water onto their property. They allege that the city of Akron puts water into a creek that is not the creek that runs next to their property. It's a creek somewhere else, and then the water eventually makes it to its property. It is just as attenuated as a regulatory taking. There's lots of intervening circumstances that occurred throughout that process. They're not saying that they did not let the city of Akron is the only entity that puts water into that creek. They're not alleging that the city of Akron is putting it directly onto their land. And that's why it's more akin to the Clifton and Moore analysis of the regulatory taking than it is to a direct physical taking where the city of Akron were to come on, build a parking lot, build a sewer system, or do something on the property. And that is just not occurring in this case. And furthermore, when you look at the way the statute is written, 71901J, which seems to be where they're focusing a lot of their attention, it talks about building sewers, ditches, drains, bathhouses, water closets. It talks about building structures. There's no allegation in the complaint that the city of Akron has any intention to build a structure on this property, or that's reasonably necessary for the city of Akron to build a structure on this property, which under 71902 is the requirement that you need to make the take of property outside of your jurisdiction. It needs to be reasonably necessary to do it. And there's no allegation in the complaint that gets us to that point. And that's why they haven't alleged a redressable issue, because the city of Akron, under the facts alleged in their complaint, taken as true, does not have the authority to appropriate this property the way that they've set forth the facts. Furthermore, to the extent they want to rely on the 7th and 8th district cases, the 7th and 8th district cases, the 7th district case is wrong. It was wrong decided. They did not engage in statutory construction the way they should have. They simply, when you read the case, they go through the analysis on 51111 for when townships can appropriate property. And they go through pretty detailed descriptions of how that analysis works. They interpret the statute. And then they get to 71901 and they say, well, that we wish they would have been more clear about how they wanted to do this. And they said, we just think it makes sense that you should be able to build a draining detention basin on someone's property if you need to. But that's not how you interpret statutes. When the statute is clear and unambiguous, which this is, you read it, you don't add or subtract words, you just read it as is. And so therefore, 71901 does not list detention basins. It just doesn't say that. And therefore, when they try to add language in because they think that that's what the legislature wanted to do or would have wanted to do, that was a wrong decision. And to the extent that it is a questionable authority, given the fact that they don't actually engage in the analysis they should have. And similarly in the 8th district, which is the Dorian case, in that case, the 8th district had a different question for it. Someone was alleging, you can't take it for detention basin because 71901 limits what you can take for. And the 8th district, and that was taking place within the city of Cleveland. It was under the home rule auspices of the city. And the 8th district said, no, 71901, when you look at it within the terms of the city, it expands the authority to appropriate property within the territorial jurisdiction of the city. It does not limit it. And even if it were to have limited it, it does not explicitly limit it. It does not explicitly say what you can't build. And they said, on top of that, the detention basin could theoretically fall within 71901J's provisions, and therefore we think it would be okay. They were looking at it more from a negative standpoint. Does the General Assembly intend to prohibit detention basins within the city? And they said, no, they didn't intend to prohibit it. The 7th district looked at it from the affirmative, but didn't engage in any analysis. They just said, we think it makes sense, we wanted to have this happen, and they ruled the way they did, but it was the wrong decision. If you read the statute and read the words, it does not say detention basin, and therefore it is not one of the reasons you can take outside of the jurisdiction to build. Furthermore, even when you want to use the analysis that they're discussing within these other cases, it's very clear when you read 71901. It's to build like systems, like sewer systems. You don't just put, like, the idea is you need to be reasonably necessary for your sewer system. There's no system here. This property is not, there's no allegation this property is any way connected to the city of Akron's sewer system. And therefore, to the extent you want to make an argument that, well, there's a detention basin here, well, no, there is no structure here, and furthermore, it's not connected to anything else. So it wouldn't be it's not possibly part of a sewer system the city of Akron is trying to construct, and nor does the city of Akron have any intention to construct something out there. And I think that one of the questions that really needs to get asked in this case is, there's a lot of ideas of, well, Clifton Moore, they're limited to their facts. They don't stand for the idea that, they only apply to regulatory takings. Even assuming that is true, which the city disagrees with, but even assuming that is true, where does the authority to appropriate property outside of the city's jurisdictional limits come from? They can't answer that question because it doesn't exist, except where 71901 permits it, or under the Constitution, which they've not articulated where under the Constitution they would find that. Because they cannot point to where the power to appropriate outside your jurisdiction actually exists, therefore the mandamus action couldn't be granted.
Well, that would be an affirmative if we're gonna go out and do this. That's not a, oh, look what happened because if we did this.
No, mandamus, but the mandamus can only can make a governmental entity do something it's authorized to do. You cannot get a mandamus seeking the city of Akron to overthrow the state of Ohio or something. Like, we can't do that. Like, you actually have, like, you can't say the city of Akron needs to print its own currency. The city's not authorized to do that, therefore the mandamus could not be issued under those circumstances. In this case, we could not appropriate property outside of our territorial jurisdiction because we don't have the authority to do that. So you tell us, go appropriate this property you're not allowed to appropriate, that is not what a mandamus can possibly be issued for. And that's why it's not the redress they're looking for in this case, and that's why they don't have standing here.
Should toggle back to the no other adequate remedy of law for what happened.
Well, I would say, the city of Akron is, as they point out, is the last remaining defendant in this, or relator in this case, and, or respondent, I apologize, respondent in this case, and just because they don't have an adequate remedy against the city of Akron does not mean they don't have an adequate remedy at law. That they dismissed ODOT because they didn't want to go down to the 10th district. They dismissed the county for reasons we don't know. And there's other governmental entities that are involved and definitely involved in this area around this property. Just because the city of Akron is not the entity that you can get redress against does not mean that there's no remedy at law for them.
Right, and nobody's conceding any of that. I just,
Yeah.
with a physical taking versus a regulatory taking in a mandamus action regarding adequate remedy of law, kind of gets back into what you were earlier discussing about what we have the authority to do versus what's been done, if you want to take the allegations of the plaintiff's true.
Well, I mean, there's still other, they could really, to the extent that they want to be, just because you don't get a damage does not mean there's no remedy available to you. There are other ways, maybe there are potential options that I haven't thought through their side of the case on that front, but.
Right, and it's, I may have brought us a little too far afield here, and you're just about at the end of your time, but because the court didn't make its determination on whether or not the mandamus action rises and falls on the adequate remedy. It's just that when we're talking about what's the difference between a physical and regulatory taking. So I guess I apologize for.
No, and the fact is, whether it's physical or regulatory, under Ohio law, there is no difference. The Clifton case fell on the fact that there was no authority to go outside for the purposes that they wanted to allege a taking. It's just like, sorry.
Okay, so let me ask you a question. So, does the city of Akron own, just by deed or title, any property outside the confines of the city of Akron?
I believe the answer, that's outside the scope of the case, obviously, but I think the answer is yes, at some point, there is some, but they were taken for purposes that were, to the extent we do, it's for purposes listed in the 719.
So we're not asking, in those cases, they're not asking to extend the boundaries of the city of Akron to include these properties?
No.
The city of Akron's, it's by its own boundaries, but the city could own property outside the confines of the borders of the city.
The city is capable of doing that, but the question is whether it would have to fall under I think if the city were to try to purchase, it could do it, like it would actually just, were to purchase, but also if you're gonna take it by eminent domain, like you would actually have to, take it via one of these, reasons in 71901.
Affirmatively.
Yeah, affirmatively, they have to be for one of these reasons.
And counsel, I regretfully need to inform you, utilize the entire 15 minutes.
Thank you, Your Honor.
Counsel, you have about 2 minutes, 15 seconds.
Thank you, Ron. And And Judge Schaefer, I would like to address the question that you just asked, Mr. Brimmer, and that is, yes, the city of Akron does own property outside its limits, including the Magator Reservoir, which was taken by eminent domain in the 1930s, where there was a dam constructed over the part of the a tributary to the Little Cuyahoga River. One of the purposes for taking that was not only to provide industrial water to the city, but also to help control flooding coming from the Little Cuyahoga River. So the short answer is yes. Judge Hensel, get into some of the issues of a mandamus. Again, as you seem very aware, the three elements of that would be that we would have to show that our clients had a clear legal right to the requested act of the eminent domain proceedings, that the city has a clear legal duty to perform that act, and then also that our clients have no adequate remedy in the ordinary course of the law. Your Honor, I would submit that the constitutions of the United States and of the state of Ohio impose an obligation and a duty on every government entity to compensate landowners when that government entity either decides to go the usual route and institute an eminent domain action, or the other way around. If they have used the person's property for a public purpose, they have a constitutional duty to compensate that person under the Fifth Amendment and under the Ohio Constitution, to give them the fair market value of their property. So that would be the clear legal duty. And as far as our clients having an adequate remedy in the course of the law, I think when the city is talking about that we released other possible defendants from this, they're confusing the idea of a possible remedy under the law against various and sundry other parties. The fact of the matter is that our clients have no legal remedy against the city of Akron for its actions in this case, irrespective of any other potential party, when they have no other cause of action other than an inverse condemnation action under Ohio law. And if they were to attempt, the only other thing that's remaining to them is a federal breach of civil rights action in federal court, which does not ripen unless they have no action in state court. So there is nothing. And on those grounds, I thank you and ask you to reverse.
Thank you. Thank you both for your presentations today. The court will take the matter under advisement, issue a written decision which will be mailed to both sides as well as